Boats that bring culture, a wisdom spurned by Australian lawmakers to the detriment of Australian families. Why we are all vulnerable to grave robbing by lawyers. Our multicultural society has evolved as a result of worldwide events. These events have resulted in a large number of overseas families deciding that Australia is a good place to re-establish their families after social disruption, including war, revolution, and the breakdown of law and order within the countries of their origin. These people came to Australia in boats and aeroplanes, which I call culture. They often arrived in Australia with no material wealth and relied upon the culture they and their family members brought with them. Their cultural input was so influential that the Australian government invented the word Multicultural Society for the phenomenon. These people have spent their lives working hard in order to help their children establish their families in Australia. These families, apart from overcoming language and cultural barriers, are thrown in at the bottom end of the socioeconomic ladder. Inheritance within these family structures plays a major role in their intergenerational development, as it plays a major part in determining the schools we attend, the suburbs we live in, the ability of our family to pay for critical intervention services during our lives, and the holidays we spend together with our family. It influences the lives of our children, our grandchildren, and our offspring for eternity. These families are particularly vulnerable to inheritance abuse by the current legal processing system of inheritance matters. They are more likely to appoint a lawyer as an executor because they are deprived of any extended family network through the act of migration. They are less likely to have access to a permanent and trusted family lawyer. They will be unfamiliar with how the inheritance law works within Australia, and that because they have been constructed by lawyers in a nation that invented terra nullius, are devoid of family input and fail to recognise the importance of healthy intergenerational family development through inheritance. We all know that on average wealthier people live longer and have happier lives. That is why so many of us work to earn more money so as we can become wealthier. Another component of wealth stems from inheritance. The wealthier the family heritage, the wealthier generally are the offspring, provided factors impacting adversely upon that inherited wealth, including war and acts of barbarism or theft, are not enacted upon the family. In our contemporary democratic and multicultural nation, Australia, we are educated to believe that we can trust lawyers. We know that when we hire them, we're normally dealing with issues of life-changing significance, either for ourselves or for our family. In such an important consumer relationship, we have to be assured that we can trust lawyers. The laws regulating lawyers bind them to their clients through the relationship of trust. So important and fundamental is this trust between the public and the legal profession to the rule of law that our government finances the Office of the Victorian Legal Services to the Commissioner to ensure us that any lawyers who are untrustworthy will be disciplined, so as we can be assured we can trust our lawyers. Did you know that if you appoint a lawyer as an executor to your estate, that when they become the executor and you are dead, they are no longer bound by the Legal Professional Act and are not deemed to be acting as a lawyer by the Victorian Legal Services Commissioner. Furthermore, no rules have been written for lawyers who are acting as executors of deceased estates by the Law Institute of Victoria. I wonder why, but methinks it's got something to do with a very big pot of gold. Oh yes, did you also know that lawyers in private practice are not bound by the Victorian Charter of Human Rights? Last time I gazed in the mirror, I saw a human, even though some may not see me as such. I have never seen dogs or cats entering lawyers, officers, only humans. The failure of our legal profession to allow culture and family to incorporate into lawmaking processes in Australia is a disgrace to which the growing distrust of our community towards the legal profession can be attributed. Access to justice is no longer affordable to the average Australian, apart from when they are dead. Then it appears as if there is a never-ending pack of lawyers who will appear to defend one's interest, provided there are assets left on your carcass from which they may gorge themselves, to the horror of your offspring. One has to ask why this is so, particularly when we have all recognised that we are a nation of families, many of whom have recently migrated to this land. To see the problem, one has to analyse the socioeconomic background of the legal profession. The majority of lawyers attend private schools, which mean their families sit at the higher end of the social spectrum. The families have more money, are better educated, and because they have a high level of literacy in the English language, their children inevitably have a greater chance of getting the marks that will allow them to become lawyers. The exercise is self-perpetuating and is an intergenerational transfer of legal power from one generation to the next within a confined social group. Due to the historical structure of this group, people who make up the majority of the legal professions, vested interest often dominates over social need when it comes to reforming our laws. The group itself can exert influence upon who will be given positions of influence and who will be excluded. The legal profession currently has a serious conflict of interest by failing to develop a low-cost, efficient, timely and truth-seeking process to deal with inheritance matters, and through its inactions is impeding the intergenerational development of migrant families who have given up so much of their lives so as to re-establish their families in Australia. The legal profession has been negligent in its duty of care to the Australian people by failing to incorporate this valuable cultural resource into the development and formation of our laws, instead allowing Australia to remain tied to the rule of the lash and the culture of a prison. Even though we have invented a new society with a new culture, our legal profession has become delusional in preventing this culture to participate in the formation of our laws, as we still operate under the format of a prison. Until family becomes the dominant influence during the lawmaking process, we will never be able to cross the historical divide between convict settlement and nationhood. A cultural shift that abhors grade robbery will not occur, and this will inevitably damage your family development. What's the difference between a lawyer, executor and a grave robber? Answer from the Moonee Ponds Bowling Club in Essendon. Well, not very much. From Collingwood, the grave robber carries the scent of the rotting corpse. The lawyer masks it with the scent of privilege. From a very good friend of mine, Socrates, the grave robber waits until the person is in the grave before going about his foul business. The lawyer executor is planning the robbery whilst the person is still alive.